Hello, I'm Ken Carlson. I'm an attorney specializing in tenant rights since 1980. This is the next in a series of free legal consultations on your rights presented by my website, caltenantlaw.com. This consultation concerns a lawsuit that the landlord may have filed against you regarding a large amount of money for rent. It probably is about money you would have paid while the COVID restrictions preventing your income were in place. More specifically, this is about how to win that case, suing the landlord, and at least greatly reducing the amount that you might have to pay. It's important to understand how we got into this mess to see how the different solutions work. When COVID hit in March 2020, the government didn't know what to do, and, erring on the side of caution, the governor ordered businesses to close and people to shelter in place. Meanwhile, rent became due, but tenants had no income to pay it. For rent due between March 1st of 2020 and September 30, 2021, called the covered period, landlords could not evict tenants for non-payment, but could later sue in small claims court for any amount. Congress sent out trillions of dollars to states for rents accruing after that covered period until March 31st, 2023. Landlords were supposed to apply for that money and not evict the tenants, but they evicted the tenants anyway for fake reasons. Now they're coming after you for all the unpaid rent. A process server leaves you a summons and complaint if it's a regular Superior Court action, or a plaintiff's claim if it's a small claims case. You may be aware that the normal maximum you could sue for in small claims court is $10,000 and up to 2 such cases per year. However, the legislature let the landlord sue for an unlimited amount for rent accruing during the covered period and an unlimited number of cases. The landlord could literally go to a small claims trial and get judgments for millions of dollars in a single day. In any battle, one of the most important features is where it will occur. Just like in sports, there is the home team advantage. Getting your case to the right place can make all the difference. There are 3: small claims court, regular court, and arbitration. In small claims cases, you're in trial in about a month or so. The whole procedure is designed for the simplest of conflicts, like getting your money back on a broken toaster. It is not designed for the types of landlord-tenant issues that you would need to discuss in your case. The small claims judge has little or no understanding of the complexities or special laws involved and no interest in learning. The judge or commissioner assigned to do the small claims case is generally not the brightest of the bunch and shows little interest in following the law. Often, it's just a lawyer volunteering to play judge for the day, called a judge pro tem, who probably knows nothing about landlord-tenant law. The judge will usually allot only about 5 minutes for each case. The landlord takes up 4 minutes, and then the small claims judge gives you 1 minute to explain all of your complicated defenses. In the end, the gavel goes down and says that you owe whatever the landlord claims, and you never did get a fair chance to present your case. Legal technicalities, so important in landlord-tenant law, go out the window. If you've seen Judge Judy or that type of show, you saw how it really is. Although you do have the opportunity to appeal that decision and have a new trial in front of a different judge, you still don't get the chance to really defend yourself, and it can be even worse. It is a trial in name only. If you do decide to stick with the small claims court, you cannot file your countersuit for any more than $10,000. At trial, you can refuse to have a commissioner or judge pro tem hear your case under California Constitution Article 6, Section 21, and you may get a judge who knows and will follow the law. A regular case is anything that is not small claims. Procedurally, it's much more complicated than small claims, but nothing you can't easily understand. The case is a limited one if you're suing for $25,000 or less, or an unlimited one if you're suing for more than that. In a regular case, which can take years, the summons and complaint is delivered to you. You have all of the normal ways to contest it, starting with a motion to quash if they didn't serve you correctly, a demur if they didn't properly accuse you, and the right to a jury trial, which is not available in a small claims case. If your case takes a week to thoroughly consider, you have the week. Most importantly, in a regular civil case, you have the right to conduct discovery to find out what the landlord's evidence is, what his case is based on, and what claims he makes. That way, you're not surprised at trial by a whopper that you could have disproved. For example, if he claims that he called you to tell you X, you can show no such phone records of that call exist. He's a liar. There are different types of discovery. Production requests get you things like your rental ledger, repair receipts, letters, notice, photographs, and other evidence that can help you prove your case. Admissions reveals things that are true so you don't have to prove them, or, if denied, to provide you the facts, witnesses, and evidence that support each denial. You can ask questions called interrogatories, or even take the deposition of the landlord or witnesses in front of a court reporter. You can subpoena people and evidence. You need a lawyer's help for this, but given the money at stake, that investment in a lawyer is well worth it. Form rental agreements will usually have a special provision that, if a dispute arises, you have to go to arbitration or mediation first before filing a lawsuit. Arbitration is where you hire a person to do the judge role and give you their opinion on the case as a sort of dress rehearsal of the trial. Mediation is where the person you hire tries to get you to settle the case. Of course, you can always negotiate without the expense or formality of either mediation or arbitration if both sides are willing and reasonable. The primary benefit of arbitration and mediation is that you get the landlord's evidence, claims, and legal reasons for their position. At least you can then understand what each other is claiming and why, so that you can settle the case. Unless it's binding arbitration, you can accept or reject the result and continue with the lawsuit. If it's binding, then the court will just rubber stamp the order of the arbitrator and final judgment is entered, ready for enforcement. Arbitration and mediation can include discovery, such as an informal but required exchange of evidence and a candid discussion of your legal points in dispute. That can make the discovery process of a court easier or unnecessary. If you can settle the case through this process, it's a faster and cheaper way than lawsuits, and you can still have a judgment that's enforceable. What you want to do, in most cases, is transfer the landlord's case out of small claims court into a superior court case, and from there get it into arbitration or mediation if your rental agreement requires that. To do that, you file your own superior court case against the landlord and have the small claims case transferred to join yours, and from there have it ordered into arbitration or mediation. If the landlord's case is already filed in superior court, then you just have the judge order it to mediation or arbitration. By doing this, you have taken control of the lawsuit away from the landlord, placing it where you can fully explore and explain your case at trial. It's unnerving to the landlord and a disturbing sign of things to come. As you might have seen in my related consultation about winning an eviction for non-payment of rent, there are many defenses that exist which you may not have even imagined. By countersuing the landlord, which you could not do in an eviction, you have the ability to turn the tables, going after the landlord to pay you, in addition to offsetting his claims by yours and defeating the landlord's case. The laws created since 2020 to deal with the COVID crisis required you to file forms and other procedures to qualify for help. Almost all of those have ended, and their protections are gone. Meanwhile, the economy is still struggling. Many people are still unemployed or reemployed, but nobody has the money to pay what the landlord is suing for, and most are just covering current expenses. It's a terrible predicament, unless you know what you can do about it. After the Civil War, California's first legislature created thousands of laws, including Civil Code 1511. It's an extreme law for extreme times. The Civil War had disrupted a lot of contracts, and government regulations prevented people from doing what the contract required. It was chaos. This law says that if you are prevented from doing what the contract requires due to government regulation, like the government shutting down businesses and requiring you to stay home, then you are excused from doing it. You're not in breach, as the landlord's complaint claims. You are excused from paying rent. Maybe not forever, but at least until you are able to pay after recovering from the effect of that shutdown. By then, the statute of limitations may prevent the landlord from suing you, and you are permanently released. In one of your defenses to the landlord's lawsuit for breach of contract, you say that you were excused from paying due to the COVID regulations under Civil Code Section 1511 and are still unable to pay due to the lasting effect of those regulations. Here's an interesting twist. In an eviction case, you have the right to withhold rent if there was a substantial reduction of habitability, such as from a single item like no heat during the winter, or any combination of things that are collectively substantial. The catch is, in an eviction, you may have to pay the reduced value of the rent as the judge or jury determines in order to truly win. In contrast, a breach of contract case presents the defense that the landlord did not perform a condition precedent to your performance, meaning what the landlord had to do first in order to make you do something. The implied warranty of habitability is just such a device. Before the landlord can require you to pay, he has to first provide you a habitable place to live. It's not merely a legal duty, but a warranty, which gives it the power of enforcement. If he did not fix everything, then he cannot sue you for the $100,000 or whatever, because he did not satisfy the warranty first. It doesn't even matter that the things he didn't fix were unimportant to you, only that they existed. You can download the habitability worksheet from the caltenantlaw.com website to help you identify every uninhabitable condition in the place. It's not just an offset as it is in an eviction, it's a complete defense to the rent claim. While rent was not being paid all that time, your impatient landlord was probably giving you eviction notices to scare you into leaving. Get out, get out, get out. The notices said that the landlord was terminating the tenancy, declaring a forfeiture of your lease, and effectively tearing it up. You didn't leave because, you had no money and no place to go. You might have gotten several of these over time, each claiming to be terminating the lease. So, if he's suing now for breach of contract, it's the one that ended when the first notice expired. That is, if he gave you a 3-day notice to pay rent or quit in April of 2020, and you've not paid him any money since then, there was no contract in effect starting May 2020 through today. If there's no contract, there's no rent due, and he's suing you upon a fictional lease that he claims continued despite his murder of it in April of 2020. We call it a zombie lease, one that came back to life on its own. Well, they don't. Even if the notice says that it supersedes all prior notices, no, it doesn't. You have to expressly agree to the landlord's withdrawing of a prior notice, and you certainly don't agree. There are colorful metaphors to describe this dilemma of the landlord. Hoist by his own petard, shot himself in the foot, caught in his own trap. By trying to scare you into moving, he prevented himself from suing on a lease that he killed, and now he gets nothing, at least for anything after that first notice expired. This actually happens quite often. Fraud is lying to the tenant to trick them into doing something like signing the lease and committing to a year. He may have made promises that he didn't intend to keep, such as to make repairs prior to the tenant moving in order to get the tenant to commit to a lease for top dollar rent. Deceit is like that, but involves concealing information from the tenant that the landlord is obligated to disclose. There's a special relationship between landlords and tenants, where the landlord is legally obligated to disclose conditions or circumstances of which he knows that reasonably could affect the tenant's decision to rent, such as a rat infestation, slow drainage, or a high crime area. By not telling the tenant about these, the landlord is impliedly representing that the place is in perfect shape, knowing it is false. The tenant who is a victim of fraud or deceit has the legal right to cancel the lease from the beginning because, you were cheated into signing up. You may not have known that the landlord knew about this falsity until years after you moved in, although you knew about the conditions themselves by living there. If you void the lease, the landlord's lawsuit for breach of contract fails. He gets nothing. Like the zombie lease, if you had a lease that expired by its own terms, it no longer exists, and no rent is due. For example, your lease ended in August 2020, and you've been there ever since without paying any money. No rent is due, and there's no breach of contract for not paying it. Exceptions to that are if you paid rent after the lease expired, or if the lease automatically renewed. The money landlords got from the government as the COVID relief fund doesn't count to reinstate your lease because it wasn't you paying. It was corporate welfare. Just staying in possession doesn't create an agreement because the exact terms have to be mutually agreed. There are several other reasons why you may not owe the money the landlord is suing for. The statute of limitations may have passed, so it's too late to sue you now, particularly on an oral rental agreement with only a 2-year statute of limitation. If the building was illegal, such as a garage converted to an apartment or a house turned into a duplex, then no money is due, and you can sue to get all of your money back. If you're not on the rental agreement, just as the friend of the named tenant, you don't owe any money to the landlord. If the landlord was cited by government inspectors for defects that were also uninhabitable conditions that the landlord didn't fix within 35 days, the landlord has no right to demand rent. If the rental unit was not registered under a rent control law requiring that, no rent is due. If the lease was made by an unlicensed offside property manager who is named as the landlord, the lease is illegal and no rent is due. If the landlord seeking the money was not the owner or a legal agent of it, there may be no entitlement at all. Scammers pretend to be the landlord, preying on tenants who don't know who the real landlord is, and file cases like this hoping to get some money in settlement where they're not entitled to anything. The list goes on, but you get the idea. You may have one or more of these defenses to raise, and keep the landlord from collecting anything. A lawyer can help you identify which ones are best for you. The landlord can sue you for the reasonable value of staying there, which is not necessarily the contract rent. The condition of the place, being threatened with eviction, and all the other factors make that amount unpredictable and debatable. The problem that the landlord faces in that kind of claim is that renting to you after the lease expired had to be something that you requested, and you probably didn't request it. In fact, you probably got an eviction notice which terminated the lease, so you stayed in possession to contest the eviction, not asking to stay there longer. You would not be alone in filing bankruptcy these days. Everyone has maxed out their credit cards, exhausted all their savings, run out of loans from friends and relatives, lost unemployment payments, and are still struggling with anything to have an income, like Uber driving. If one student fails, it's the student, but if everyone fails, it's the teacher. Here the economy has failed, and the government is doing nothing to revive it. If you're being sued for a huge back amount that you just can't pay, you can file bankruptcy. Chapter 7 is a complete liquidation where you walk away from your debts and start fresh. Chapter 13 is a rescheduling of back amounts, paying pennies on the dollar while still paying current obligations. Chapter 7 is the simpler, much cheaper, and less risky of the two. The bankruptcy would wipe out your debt to the landlord, but leave you free to continue suing the landlord for your claims, unless the bankruptcy trustee rules otherwise. That certainly turns the table on the landlord, who starts out suing you. You incinerate his claim with the bankruptcy, and then sue him for 6 figures that he'll have to pay you, perhaps paying out of his own pocket for his legal defense. With the unprecedented failure of the economy, it's unclear what the credit world will make of all this. The economic collapse devastated the model where it was the failing student with the low grade that set the standard. As a practical matter, the credit evaluations should reflect the financial responsibility of the person, their reliability in paying their bills and repaying their loans. If someone had a good credit score prior to COVID and then fell apart, including bankruptcy, because of COVID regulations and the economy, those events are not an accurate reflection of the creditworthiness of that person. Their conduct before COVID hit is the more reliable information. The point is, your concern about filing bankruptcy and damaging your credit may not be well founded. You can ask a credit repair expert about that. Just the fact that you are seriously considering filing bankruptcy may be enough to back off the landlord's case. The landlord doesn't want to spend a lot of money fighting a lawsuit that, 1, may be riskier than he once thought, and 2, at best, results in a judgment that bankruptcy wipes out. It's good money after bad, they say, and best to cut his losses and forget about collecting from you at all. Tenants are often so afraid of causing problems that would result in an eviction and compounded problems that they don't even think about suing the landlord. Or for what? That all changes when the landlord is suing you, because you have to defend yourself and you're already in court by no choice of your own. In fact, most tenants have no idea how many things they can sue the landlord for because, you don't know much about your rights. And the lease seems so one-sided. It says, we get everything, you get nothing. But that's not true. It's just part of the landlord's scam to keep you in fear, afraid to complain, and willing to stay silent in order to avoid being evicted. You forget that it's a contract where the landlord has to do his part because you know he'll threaten you with eviction for being a complainer. That's what oppression is, making you afraid to assert your rights. In the tight housing market, the landlords get away with it, but that will soon end when the tenants leave the cities and vacancy rates soar. Earlier, I talked about suing the landlord for fraud and deceit and recovering money for an illegal unit. Those are just the beginning. Having an uninhabitable place is a breach of contract, and you may have tolerated it for a long time, but those conditions may also have been a nuisance. You may have made repairs that the landlord wouldn't do, and you can sue to recover those costs. Late fees are illegal in residential rental agreements, and you can sue to recover those. You may have moved out, and your landlord didn't return your security deposit, so you can sue for up to triple the deposit. The landlord coming into your home without a proper purpose or notice is trespass and an invasion of your privacy. The landlord threatening you with eviction for asserting your rights to be excused from paying under the COVID regulations or for complaining about repairs is illegal retaliation. The landlord may have violated several COVID moratoria, such as threatening to evict you or illegally raising your rent, which may have penalties like $5,000 per violation that you can collect. You may have been forced out of possession by the landlord's construction work, incurring temporary costs of relocation or permanent relocation expenses. You may have gotten sick from mold infestation or inadequate heat as a personal injury claim. The landlord may have failed to provide adequate ADA accommodations if you're disabled. The landlord may have sexually harassed you. The landlord may have told other tenants about your personal information, which is an invasion of privacy. The landlord may have slandered you to your neighbors and friends. The landlord may have stolen your personal property, including refusing to give you your personal property back after you've been evicted. The landlord may have taken over part of the property rented to you or let others do so. You can sue for all of this. The list goes on. You get the idea. Maybe some of you had this strike a chord, and now you remember what you tried to forget. What kinds of things can you sue the landlord for? A lot. How much money? A lot. It depends on how you present your case, the facts, the law, and the help you get. And don't worry about collecting from the landlord. Oh, you can have the sheriff put the apartment building up for sale, or even the landlord's home. You can take his car and sell it, levy on his bank account and business, his boat, RV, stocks, gold coins, etc. You can have the landlord come into court for a judgment debtor examination, where he has to tell you where everything he has of value, or he goes to jail if he doesn't. That's humiliating. He has to pay for all the extra costs of your collection efforts on top of paying the judgment to you. Don't just sit there. Get going on this now. You have the right, you have the power, and you have the motivation. The landlord wanted a war that he can't win. You owe it to yourself. And do it for the sake of any future tenant that he'll be afraid to treat like he did you. Teach him some manners.